This is the second and last of the two seminars that UCL and 8 News Square have organised. This time it's not on the direct methods of treatment and finding COVID and preventing it, but on the consequences in intellectual property and competition law of the crisis. My job is only to say good evening, I've done that, and to hand over to Daniel Alexander, who is the chairman for this evening. The 8 News Square man, but he's also a UCL professor.
Thank you very much, Robin. Well, good evening, everyone, and welcome to this IBIL 8 News Square webinar. It's particularly good to see, or at least see that many of you are here, since a lot of people are suffering by now from heavy Zoom fatigue. Just a few basics. First of all, while the session is progressing, you will be centrally muted. A number of participants and those in the audience have sent in questions, and I will be asking the panel to address as many of those as we have time for at the end. If questions come in during the session, I or Lynn or Lisa, to whom I'm very grateful for organizing this session, will select some of them and we'll have those as well if time permits. We found it rather easier to do that through the chair rather than inviting individual people to unmute and ask the question directly. Our previous session focused on patents and regulatory issues. It was only last week, but at least to me, it seems like an age ago. Since then, there's been some easing of lockdown, but I think more importantly, there's a psychological sense that people are looking much more to the future. The Chancellor of the High Court, as many of you will know, gave a lecture only yesterday focusing on the positives to be taken from the enforced remote working regime, some of which may become permanent features of the legal landscape. So in our discussion this evening, the panel is going to focus on three broad topics. First, issues in copyright law thrown up by COVID-19. Second, issues relating broadly to privacy. And third, some of the competition law topics. Uniting these themes is a wish to look to the future and examine what lessons can be learned from the crisis, which may be of longer term importance. Robin Jacob last week quoted Cicero, "In times of war, the law is silent." We might say that at the moment, what we are perhaps thinking about is whether war or times of war can teach us what the law should say in times of peace. And one of the common questions here is whether the legal framework in IP is actually fit for purpose, both in terms of war, but times of war, and in times of peace. And a resource-constrained environment puts those questions into sharp relief. So with that, can I introduce our panel? First of all, Dr. Emily Hudson, who is a lecturer, Director of Undergraduate Studies, and Chair of Assessments at King's College London, which she joined 5 years ago. She's written widely on intellectual property law, including in particular copyright exceptions. Her research interests include other aspects of property law, including especially as they relate to cultural institutions and creative industries. Dr. Paul Erris is an academic historian specializing in the Reformation. He's a fellow of the Royal Historical Society and acts as Pro-Vice Provost for Library Services at UCL. He's also Chief Executive of UCL Press. So he sees things from the angle of producers and consumers of academic works. He was a president of the Association of European Research Libraries, including a member of its Citizen Science Committee. Emily and Paul will start off with a session jointly focusing on copyright. We'll then turn to Michael Veale, who is a lecturer in digital rights and regulation at UCL. His expertise sits at the intersection of computer science and technology, particularly in the context of fundamental rights. He's written widely on legal issues relating to advanced data analysis and has previously worked at the European Commission. He'll be looking at some of the privacy and regulatory issues. And Dr. Chris Stothers, who is a partner at Freshfields and a visiting professor at UCL, has particular expertise at the boundary of competition law and intellectual property. He supervises doctoral students here on SEP and FRAND issues and is the author of a textbook, Parallel Trade in Europe, Intellectual Property, Competition and Regulatory Law. And Chris is going to look at some aspects of competition law, particularly relevant to intellectual property and the regulatory changes that the crisis has brought. So with that, I turn over to Emily.
Thank you very much. So in this copyright aspect of the session, we're going to focus on the impact of the pandemic on the services and activities of educational institutions and libraries, with a particular focus on the higher education sector. And I'll focus on the technical copyright aspects, and Paul will then talk to commercial and more pragmatic matters. The comments that I'm going to make draw from an article that I co-authored with Paul Ragg from the University of Leeds, and from my book, Drafting Copyright Exceptions. The article is available on SSRN. It is very detailed. So for the purposes of tonight, I'm going to take you through a highlights package of some of the key ideas. And we set the scene in the article by talking about how the pandemic has affected higher education. And we identify two particularly important changes to the usual activities in universities. Firstly, the closure of libraries, and secondly, the movement of assessment and teaching online. Importantly though, we also argue that the issues raised by these changes are not new. Instead, the pandemic has produced a more extreme and urgent version of the existing situation. So, for instance, consider the closure of libraries and what that means for the asymmetry in physical and virtual holdings. Now, during the pandemic, the issues caused by this asymmetry are more pronounced because students and staff can't actually go to the library. But some of the concerns raised by the library sector and university sector in relation to the availability of digital content, the pricing of ebooks and so forth are long-standing. And actually at this point, I might briefly have Paul just say a few things about his experience with the ebook market and the UCL experience as well.
Yes, thanks so much, Emily. It's a great pleasure to join you in this webinar. So I'm a university librarian. I've been a university librarian in UCL for 20 years, and libraries are undergoing, even before the pandemic, an enormous change in their role. Historically, libraries have been seen as collecting spaces full of books, paper books and paper journals, and the traditional view of a library, the great 19th century architecture of libraries, the British Library, the Dawson Reading Room, Veale. These buildings are built around the concept of the library as a physical collection. But even before the pandemic, libraries were changing because libraries were not simply seen, we don't simply see them anymore as collecting spaces. They have two further functions. They are student-centric spaces where students learn and can work at their own pace, choosing their own tools, digital or paper. And they're collaboration spaces as well, where group work and project work can continue and develop. Universities are very bad on the whole at providing collaborative spaces. The traditional library concept of a great architectural building isn't drawn up around the concept of collaboration. It's drawn up around private study of paper collections cited in that space. That doesn't work in a COVID-19 situation because certainly for the first term next year, large lectures look like being impossible because of social distancing rules. And reading rooms in libraries will not be open in the normal way for the same reason, social distancing. You can't get so many people into the library. In UCL, we would expect 5 million visits a year from our students. And that makes us easily the most heavily used university library anywhere in the UK. That won't be happening in the next 12 months because of social distancing. So how do you deliver learning? How do you support our 43,000 students in UCL when all these physical libraries are closed? Well, in an ideal world, you would provide them with digital content, e-textbooks, where they can read on the screen in digital format the types of paper copy that they're used to accessing, but will no longer be able to access, certainly for the beginning of the next academic year in physical libraries. Now, in UCL, my library would normally pass 20,000 books to the catalogue each year. We buy 20,000 books with the book budget that we have, and these go through to the catalogue and are available for our 43,000 students. But if I were to use that book budget and buy e-textbooks instead, look at what the result is, because e-textbooks are so very expensive and commercial publishers are using it as a way of screwing more money out of the HE sector. I could buy less than 100 e-books with the same budget that I have that buys 20,000 paper books each year. So that's simply unsupportable. It's not possible under current commercial arrangements to use existing budgets to replace paper copy with e-copy. It's a major problem for every academic library, not only in the UK, but across Europe and across the developed world, where we are trying to embed e-textbook provision into our offering. So that's the challenge. We don't have enough money. Commercial publishers are not yet willing, to relax their conditions and lower the prices. So we have a problem. And later in this talk, I'm going to hand back to Emily now. But later in this talk, we might be able to crack that. Emily, over to you.
Thank you. And I just to emphasize a couple of things. So one of the points we make in the article is that the consequences of existing issues are more pronounced. And in part, that's because we don't have access to what you might term analog workarounds. So Paul's just talked about some of the issues with the asymmetry between physical and virtual collections. Well, in the pre-COVID era of what feels like many years ago in March, students could at least turn up to the library and physically take a book off the shelf. But that analog workaround is gone. In relation to teaching, in the lower bullet point on the slide, there have long been questions about copyright's impact on teaching, whether or not a clear all rights model works, and so circumstances where an exception should apply, or whether blanket licensing would assist or compulsory licensing. But again, we just don't have access to certain solutions. So one example relates to audiovisual works. If I'm in a classroom teaching and I need to play some audiovisual content, I know that Section 34 of the CDPA is available to allow me to play that content in class for the purposes of instruction. But if I'm delivering the same lecture online, Section 34 does not apply anymore, because that provision relates only to public performances and not to online communications. Now, we argue in the article that in actual fact, one can reach through to Section 32, so fair dealing. and we argue that robustly, but we do accept that the situation is clearer in that instance in the analog world than the online world. So let me now turn to what we discuss in the article, some key points. We talk about the prevailing copyright environment. In relation to licensing, one point that I just wish to emphasize is that there have been some initiatives by authors and publishers and copyright owners to provide greater access to works during the pandemic. Some of these are time-limited initiatives. So to illustrate, Copyright Licensing Agency with their blanket license for educational copying, that the quantitative limits in that license have been extended. So that means that the license covers the copying of 30% or 3 chapters of a work rather than 10% or 1 chapter. And that extension is due to expire on the 30th of June. So there are initiatives from the authors and rights holders. We also then focus on exceptions. And I think one of the key ideas that we want to prosecute in the article is that exceptions have a lot of latent flexibility. There's lots of pockets of underexploited flexibility. There's a lot of power in the existing regime. So one of the things we say, and it's sort of a call to arms, is that the library and university sector should not concede too much regarding exceptions. So whether they're making representations to governments or other copyright stakeholders, they really shouldn't emphasize too much perceived limitations or uncertainties, because in actual fact, exceptions have a lot of work to do. And one of the goals of the article is to explain why that's the case in relation to section 32, which is fair dealing for the purposes of illustration for instruction. Now, that provision was introduced into the CDPA in 2014, and there are a number of things I think that are fairly clear about the operation of this exception. It applies to all types of copyright work. The non-commercial purpose limitation is addressed to the dealing itself. So the status of the institution or entity in which that reproduction is made is not determinative. There's a sufficient acknowledgement requirement, but this is not onerous. So it's not a full-blown academic citation. A sufficient acknowledgement is an identification of the work and its author, and there's various ways this can be done by names, descriptions, logos, and so forth. A fourth matter that is clear but does actually operate as a meaningful limitation is territoriality. So this is the idea that copyright is territorial. So fair dealing will apply to acts within the UK, but the issue for education is that we are going to have an increasing number of students who never set foot in this country. So we are preparing the next academic year to teach a lot of students remotely that will be outside of the UK. And so there is an issue of the application of exceptions and the application of copyright law to acts done by our students in other countries. So we talk a little bit about that aspect of territoriality, but ultimately it is one argument in favour of licensing solutions because they can have a worldwide application. So then a couple of matters that are perhaps a bit more contentious, and one is the meaning of by a person. We say in the article that this has to include legal entities. So it's not just the lecturer or the student, it has to extend to other members of the university team who may assist with education. So for instance, librarians digitising works for use in education, and indeed the institution itself. We also talk about what's meant by illustration for instruction. And we say that it needs to be given a robust and forward-leaning interpretation. When Section 32 was first introduced into the CDPA in 2014, there was guidance released by the IPO, which in our view took an unduly conservative approach to Section 32, and and on its face seemed to not really implement or reflect, I should say, the legislative goals behind Section 32. So that guidance suggested that illustration for instruction might have be relevant only to minor uses. More recently, we have seen some indications from the government that they think that Section 32 has a much more significant role to play. There was a letter by Research Universities UK to the government in relation to the pandemic. One of the things that the government said in reply was that Section 32 could be relied upon for a lot of acts of online teaching. And that's something which with which we agree in the article and which we say is welcome. So in the article, we then apply Section 32 in two main scenarios. First one is teaching. So in particular, use of copyright material in online classes, pre-recorded lectures and so forth. And we think that Section 32 has a lot of work to do and a lot of application in that scenario. We then deal with something which is a bit more challenging, which is Section 32 and required readings. Now, there's already a number of mechanisms that universities can reach to in relation to that digitization of reading materials, and in particular, the CLA blanket license enables a lot of copying of smaller parts to be done. So our question was, well, what about lengthier extracts or even entire books? Because as Paul mentioned, one of the issues we've got is these works for which ebooks are either not available or they're prohibitively expensive. So is there a way fair dealing could be used to allow copying of greater parts, not just smaller ones? In the article, we analyze this by reference to controlled digital lending. So for those of you not familiar with controlled digital lending, this has been rolled out in a number of libraries and universities in the United States by reference to fair use. It is controversial. So one of the leading practitioners of CDL is the Internet Archive, and they were sued on Monday in relation to this very activity. But leaving that to one side for the moment. So the key tenets of CDL are that libraries can digitize lawfully acquired physical books and then loan the digital copy as well as physical copies. A strict owned to loaned ratio must be maintained. So if there are 3 copies of the book on the shelf and you loan an electronic copy, one of those physical copies has to come off the shelf. And the loan conditions need to approximate a loan of a physical title in terms of only having a single user, in terms of the duration. And finally, there needs to be technological interventions to prevent copying and reuse by the borrower. So the idea is to approximate digitally what institutions can do with physical copies. As I said, this is argument has been made in the United States by reference to fair use and the first sale doctrine. We use the idea of CDL to say, can this inform fair dealing arguments in the United Kingdom? And we make the case that it can. And indeed, we also reach to Section 36A of the CDPA, which states, unqualified, that copyright in a work is not infringed by the lending of copies of the work by the educational establishment. Lending in European copyright law includes digital lending. And so we make various arguments as to how Section 36A combined with fair dealing in Section 32 might give universities and libraries, some university libraries, some space for copying lengthier extracts and entire works. We note that there are various issues with this analysis, not least of which is the logistical issues in actually getting all the scanning done. So we certainly wouldn't present this thinking that a large-scale CDL scheme was going to be set up in the UK anytime soon. Let me just take you now through some other arguments that we cover in the article. Research Universities UK, in their letter to the government of a few months ago, asked whether the public interest defence may provide some greater accommodations to users in the during the COVID pandemic. And we discussed this, but to highlight a few key points. The first issue is whether or not the defence exists. And our concern is that it may not have survived recent Court of Justice cases in Spiegel Online and Funke Medien, where it was indicated that member states may not derogate from the exclusive rights of authors beyond the permitted cases in Article 5 of the Information Society Directive. So that raises the possibility, which I think, I mean, there may be some creative arguments, but I think there's a good argument that at the moment, the public interest defence to copyright infringement is actually not a thing. Even if the defence exists, then what we say is that it has a clear function, and that applying it to pandemic conditions would require a radical reconceptualisation of what the public interest defence is about. So we don't think the public interest defence is going to be a useful way to go. That said, we do think there are some public interest arguments that may be relevant to remedies. So last week we heard about Coventry and Lawrence and eValve. We talk about those cases in the article, and so I don't feel the need to repeat that all here. Final couple of points. Research Universities UK also asked whether compulsory licensing might be an option during the pandemic. And the government's response was to say no. They said it would remove exclusive rights from rights holders. They said it would likely be contrary to international copyright law. We don't share the legal view of the government in terms of, we do think that compulsory licensing is permitted under international copyright law, but we do accept that it may not be the right solution during the pandemic for both philosophical and practical reasons. So the philosophical objection to compulsory licensing is basically that you're removing the decision-making autonomy from rights holders, but also that compulsory licensing leads to inefficient outcomes. The reasoning behind this is based on the idea, and perhaps those with more neoliberal conceptions of the market might be more attracted to this concern, but the concern that basically governments are poorly adapted to set prices. So the problem with a compulsory license is that the decision making about price is taken out of the hands of rights holders and put into the responsibility of the state. Those sorts of philosophical concerns about compulsory licensing. That said, one could say that even if ordinarily compulsory licensing is unattractive, pandemic conditions make it attractive because usual problems with market negotiations, so holdout, transaction costs, etc., are all the more pronounced. But here we also note that there are some practical issues around compulsory licensing, basically because of the difficulties in magicking up a compulsory licensing scheme from scratch. So one option for the government is a sort of a general guide to what the compulsory license looks like, with certain details to be sorted out by the relevant stakeholders, which we think could end up with protracted commercial negotiations that end up in the Copyright Tribunal. Or alternatively, the government puts lots of details in, but then risks that issue of what if they get it wrong. So that risks a compulsory license that's either ineffective and doesn't help the universities, or completely decimates publisher markets and so forth. So we then make another suggestion though in the, and this is somewhat of a thought experiment. This is an extension of section 36 of the CDPA. That provision allows educational institutions to copy and communicate not more than 5% of a work for the purposes of instruction, but not where licenses are available. The thinking that underpins this provision is to incentivize licensing. So the idea is that the hands of the educational establishments have been somewhat strengthened, and there's an encouragement of licensing beyond what is permitted by the exception. Similar idea was found in the Whitford Committee. They were of the view that blanket licensing was the best response to reprographic reproduction by libraries and schools and government and so forth. But they were concerned that if exceptions were rolled back to be replaced with blanket licenses, well, what would happen if no blanket licenses were available? So they came up with an idea that there would be a free-for-all exception, and that was their exact language, that if at a particular date blanket licenses weren't in place, then an exception would apply, which would allow free-for-all copying by all those stakeholders. So we talk in the piece about extension to Section 36. Where we conclude is by saying there is greater power in exceptions. We talk about what the government could do if it was minded to intervene to try and incentivise commercial negotiation and perhaps respond to some of these concerns about there not being licenses available. But ultimately what we say is perhaps there's a more fundamental problem, that we have a system of academic publishing where in actual fact we have commercial publishers who are internalising all the benefits of the work done by university employees. So our ultimate conclusion is actually maybe there's a new form of private ordering that universities need to embrace, which is much more use of open access and in-house publishing for teaching outputs. And this is something which is close to Paul's heart. So that's where I now pass the baton on to him to continue this discussion about these other options.
Yes, thanks very much, Emily. Thanks for a fantastic overview of the copyright work you've been doing and your description of the letter to the government asking for relaxation in copyright law. I was one of the signatories of that letter, so I was very disappointed, as we all were, by the government's response. Either they didn't understand or they weren't listening. So there are three possible ways forward, and the government's negative response to our request for changes in copyright legislation make us feel in libraries, because we are the people who on the ground have to deliver a solution for our new students and our returning students in September. Our feeling is that work on copyright, while it's worthy, is not going to deliver a solution in time. We're reminded of the case of Jarndyce and Jarndyce in Bleak House in Dickens, a case which went to the Court of Chancery, took years to resolve, and resulted in the bankruptcy of all parties because no adequate solution was arrived at in time. And to be honest, in terms of copyright, librarians could be forgiven for thinking, we're in that position now. So what I'm going to talk about in the last few minutes of our talk, maybe 5 minutes or so, is looking a bit more at commercially resources and the open access options which libraries are increasingly favouring. So next slide, please, Emily. So UCL Press is the UK's first fully open access university press. I established the press in 2015, and I did it because commercially produced monographs and textbooks, particularly e-textbooks in digital form, are simply too expensive for universities to afford. We're having to put a solution in place for September when we're facing cuts in university budgets. Worst case scenario of around 20%. If those reductions do come through, and it is 20%, there's no way we can afford commercial licenses for commercial e-textbooks. They're simply too expensive. And the commercial providers have priced themselves out of the market. So an option is to publish your own textbooks as a university and become a producer and publisher of academic copy. And that's what I'm showing here on the screen, because this is in UCL. We have others in the pipeline. Our first textbook is a textbook of plastic and reconstructive surgery. It's edited by Deepak Kalaskar, who's one of our clinicians at the Royal Free Hospital, which is one of the teaching hospitals that UCL uses for students on clinical placement. And he published this textbook with us in August 2016, and it's freely available as an OA textbook on the UCL Press website. And it's had fantastic exposure. It's been downloaded. The digital version has been downloaded nearly 84,000 times since it was published in 192 countries and territories, developing countries, where the digital copy, if it were produced as a commercial offering. So the model for UCL Press is to make material fully available as open access, and Deepak was absolutely clear he wanted this textbook to be open access. We do sell paper copy for those who want to buy paper. I'm not absolutely convinced why people want to buy paper in an online open access digital environment, but we do sell paper copy, and it's had about 270 sales of the paper copy, a modest sales figure. Much better to look at the download figures in terms of impact and exposure. Next slide, please, Emily. And these are the cumulative stats for our OA publishing in UCL Press. We were founded in 2015. We published 150 books. We publish journals as well, but our main work at the moment is on monographs and a growing e-textbook portfolio. We've been downloaded 3 million times in 243 countries across the world. That includes 1 download in Antarctica, 1 download in the Falkland Islands, and 16 downloads in Vatican City, which is interesting because we're a secular foundation and we don't publish theology. So whatever they're reading in Vatican City, it isn't theological texts that UCL is producing. The country where most downloads take place is, of course, the USA, and there we have around 750,000 downloads, with the UK next at around 500,000 downloads. We think this is the model for the future. Forget about the restrictions of changing copyright law. Forget about our inability to afford commercial e-textbooks. Let's produce the textbooks. Let's produce the copy ourselves, because our academics are actually writing the things in the first place. So why they're signing away copyright to commercial publishers as a condition of being published when we can make it available as an OA textbook straight away, I'm not sure. Next slide, please. So these are the country downloads of the press, and as you can see, 800,000 downloads in the USA. I slightly exaggerated the UK figure. It's about 400,000. But we're also being downloaded in a number of developing countries there. You see India, you see China, you see the Philippines, and Nigeria. There are quite a lot of downloads in Nigeria as well. Okay, final slide, please. Thanks very much. So the problems about moving to this new publishing environment is that textbooks don't count for the REF, for the Research Excellence framework. So academics say, I'm not going to write a textbook because I can't submit it to the REF. I won't get royalties for an OA textbook, so I'm not going to write a textbook. It will harm my career if I spend my time producing a textbook rather than writing research outputs, because I won't get promoted for writing a textbook. So academic culture has all these preconceptions about textbooks embedded in it. So it isn't just a question of legal frameworks, it's a question of academic culture that needs to change in order to deliver this new OA solution that I'm advocating. Next slide, please. So this is the final slide. Universities and university students are left between a rock and a hard place. Copyright restrictions are a barrier, and changing the restrictions into opportunities takes too long to deliver the solution that we need for September. It's simply taking too long. Commercially, textbooks are too expensive, and with universities expecting cuts in their budgets of 20%, there's no way we can afford commercial copy. So institutional publishing of OA materials through OA, open access university presses, is the way forward. Thanks for listening. Let's begin the discussion.
Well, thank you very much, Emily and Paul, for that tremendous tour of the law and the practical application of it. Much to think about, a number of questions coming in, which we'll get to at the end. But before that, can I hand directly over to Michael to change gear to a slightly different topic?
Daniel, hard to follow. There's a lot of great content in the last talk. So it's. I want to talk a bit about a different aspect of coronavirus. It's something that I've been working on and been heavily involved in, and it's the idea of Bluetooth contact tracing applications. I want to talk about some of the privacy issues there, but also linking to some of the IP questions and what that means for the future. So early on in this pandemic, when it was still an epidemic, myself and colleagues, particularly in Switzerland at EPFL and ETH Zurich, but also in universities like KU Leuven, we were noting that there was a huge appetite, political appetite, for maybe techno-solutionism, you can call it, but an app. People said, well, can we get out of this situation, or can we remedy it to some degree with an app? We were very skeptical of this general approach. Some countries, like Singapore, had tried this. They had a system called Trace Together. And the way that these broad systems work, different ways you could do it, but the sort of settled way around the world that these systems should work is using Bluetooth. The idea being that this is a very fast-moving disease. You can have it transmitted very quickly. It's very contagious, and you can also transmit it to other people when you don't have symptoms at all. And so you have to act very fast. So people's phones could be using Bluetooth to recognize that there is another phone nearby, and effectively could make a connection such that in the future, if one of those people is diagnosed as being COVID positive, then effectively they can notify anyone who they've been significantly close to. We're talking about within 2 meters for about 10 to 15 minutes. Over the last 14 to 21 days, they can notify them and tell them to take further action. And they can do that very quickly without the delay of a manual contact tracing process. And you can also do that for people who you don't know, such as those you are sitting next to on a bus or in a restaurant or something like that. And it also happens completely anonymously without having to tell any intermediating party, anonymously to the participants, however. So what we were concerned about here is this push towards an app. Actually, the system developed in Singapore and also proposed in other countries is pretty risky from a privacy point of view, because effectively what it does is it does two things. It centralizes a social graph, a social network of physical proximity of a population. Not entirely, not 100%, but this is really sensitive data. This is clusters of people that everybody in the country spends time near or far away from. And this is the kind of data that actually Cambridge Analytica was after through Facebook. This social network data is very rich in terms of what can be mined and learned from it. These systems, based on the way they also worked, the initially proposed systems, such as in Singapore, also were concerning because they lay a foundation for technologies such as immunity certificates and technologies of quarantine control. And these were unproven technologies. The contact tracing app system is also an unproven technology. And we were very concerned as researchers that this could eke into something that was much more invasive without the proper debate, particularly given the situation many countries are in, using emergency powers, urgency procedures, or suspending privacy and data law entirely in the case of, for example, Hungary in relation to COVID-19. So what we did is we very rapidly entered an extremely exhausting remote process of developing and designing an alternative system with a mix of law academics, privacy scholars, privacy engineers, epidemiologists from across Europe. We created a system called DP3T, and it was effectively a system that is decentralized, What this means is that you do contact tracing, you can get these notifications, this system can work effectively, but without any central database ever being created. It does this effectively by doing all the matching on individuals' phones. Legally, there's a strong case to say personal data, in the meaning of privacy law, actually never leaves your phone. So we did this, and we built this system. We were building it particularly in Switzerland, but more widely around the world. This is, we were releasing it openly the whole time, so all the protocol, which is a very important part of this, the code, the formal description of the code we were making, which is what you need to replicate it, is all CC by 4.0, and the code itself was licensed under a weak copyleft license, because we think accountability and replicability are really important aspects of this. And why we think this is really key, and why we would license this openly, is because when an interesting part of a decentralized system where everything is important is happening on your phone, is if you have access, if the public have access to the code of the particular app, they can scrutinize and they can really see how the whole system works, because everything important is happening on the phone. In a centralized system, you can't see what's happening because the really important stuff is happening on the back end in the server, and a lot of data could be linked or extra data could be collected or so on without it being easy and clear. So scrutiny is important there. And in the UK context, which we can talk about in a bit, maybe there's questions, the UK is one of the only countries in the world still choosing to use a centralized system. And one of the reasons is that firstly, almost every other country chose our approach, this DP3T approach, a decentralized system for trust, for getting more people involved without being worried that this could creep into something more invasive. But this is when the story gets a bit more strange. So quite early on, a couple of weeks after we released, Apple and Google, who you may have heard of, had came out and effectively said, our system we've built, this DP3T system, we will take that code and protocol, and we will, the idea of it, not the exact code, because otherwise they'll be hit by our copyleft license, and we will put it in our operating system. So they will put it around, roll it out automatically as building blocks for national apps to use. So you can embed code at the lower level of a phone inside the operating system that makes it easier for phones to use. We'll roll it out across the entire world. This was very important because Apple, up until this point, was a very difficult platform to work with. Apple is heavily proprietary. Android is quite permissive, and Google phones are quite permissive. Apple are quite restricted phones and devices. And these phones and devices would not let apps use Bluetooth, which was necessary, in the background. So when the app was turned off, the Bluetooth would stop working, the contact tracing would stop working. This is done for privacy reasons. It's hardwired into the phone, into the operating system, because generally Bluetooth is used to track you around a shopping mall, or if you install a Nectar app, it will try and work out your location from hidden sensors in the environment if you give it half a chance. So this is done for privacy reasons. And governments had realized that they could not make an app function without the cooperation of Apple in particular. As soon as you choose to make an app, because of this walled garden proprietary world, you are engaging in a public-private partnership. You've got no choice about it. You have to work with these providers in order to distribute and to run an app successfully, and more so if they use access to sensors such as Bluetooth. So the interesting part here was that not only were Apple and Google saying they would use our code, they also did not create changes to the operating system that would allow centralized systems, such as the ones we were concerned about, to function correctly or properly on iPhones and iOS devices. So in a way, they use the politics of protocols to choose our system over a centralized system, and to embed this code in the operating system. So where does this leave us? So we've got these, they're rolling out, our approach is rolling out across many countries across Europe. England is one of the only holdouts really in this. Even Northern Ireland has said they don't plan to use the NHS England app and instead plan to use our system as the Republic will. So there's internal UK divisions. France is an interesting case though. So France has turned this politically into a debate about digital sovereignty. That's saying that Apple should change their operating system as we tell them to. They haven't tried actually a legal instrument. They've just decided they'd have a meeting and are offended that it hasn't happened. Apple should change their operating system to allow a French, very centralized approach, which would allow this surveillance to be built on top, to be deployed. And this is an interesting debate because it opens up a lot of old questions. Who has the ability to scrutinize the code inside an operating system, a phone? Who has the ability to determine what can and cannot run in a proprietary ecosystem that a platform has established? So France is opening up this question again. And I agree, we're stuck in a very bad situation, really. The enclosure of ecosystems by platforms who seek to render the world legible by recording them in data and to intermediate, to take a slice of all kinds of transactions, messages, and information flows in the world is a big accountability problem. So to kind of finalize, in the context of COVID-19, we developed a system that we felt is much more privacy preserving, and it hopefully works well, and we'll see how it develops in the future. It's rolled out across Switzerland and Italy, for example, just in the last week. However, it has opened up these old questions about protocols and power, and it has actually made some of these questions more visible in the future. So we may see that this has become a flashpoint where in debates around who should be able to decide how phones work, there are questions about a right to repair, for example, and a right to reuse and a right to open up software. Maybe these are new potential legal rights that could be introduced. In this context, who decides? And when we think about these systems being global, and indeed these COVID apps are supposed to be interoperable across borders, and it's important they work in the same way for it to work. When we think about a global system, that becomes very important indeed, not just for coronavirus, but more broadly going forward, and affects all digital issues from copyright to data and privacy. So yeah, thanks a lot, and looking forward to hear the rest of the panel and some questions.
Well, thank you very much indeed. And you have provided a perfect segue, because whenever intellectual property law starts to talk about protocols and standards, we need to call for the competition lawyers, which is what I'm now going to do, to hand over to Chris to look at some of the competition issues. Again, we're having questions coming in. I'll leave them up to the end and try and knit some of the questions that have come in together to ask them in a compendious way. So Chris.
Thank you, Daniel. So not exactly a competition lawyer, but an IP lawyer who does a bit of competition. We've already looked quite a lot, both on the competition, on the copyright side and on the data privacy side, about some problems in the law and problems with how the law can cope with the current situation. What I've been asked to look at is areas where the law seemed to have problems and where there has been rapid change to deal with it. So I want to look at competition law, free movement law, and state aid law, but also how we've dealt with it overpricing by exploiters, which might be an area those areas of law might be seen as a proper answer to. Starting off with competition law, the problem was seen very quickly that competition law might prevent an effective response to the coronavirus crisis. And very rapidly, we had statements from the competition authorities moving quickly to try to deal with it. So that we had already on the 23rd of March, there was a joint statement by the European Competition Network, so that's the European Commission and the national competition authorities, saying that the authorities would not actively intervene against necessary and temporary measures put in place to avoid a shortage of supply. And this was a time when it wasn't so much about toilet roll, but everyone was very worried about face masks and sanitizing gel. And so, as well as saying that measures necessary to avoid shortage of supply wouldn't be stopped, equally there's concern about price rises, and said the competition network wouldn't hesitate to take action. But already there was a recognition that perhaps competition law wouldn't work very well as a way of taking action in relation to this, because the ECN was very quick to point out that even under existing rules, manufacturers could set maximum prices for their product, and that might be useful. So already, even in those very early days, even in a very rapid reaction, the competition authorities were saying, we're worried about price rises, we won't hesitate to take action, but by the way, manufacturers, you may want to, brackets, need to take action on price rises yourself. This led a couple of weeks later to the Commission's temporary framework, recognising the exceptional circumstances at the time and the need of companies to collaborate and cooperate in ways that previously they might not have been able to do. And the cooperation in question would be ensuring supply and adequate distribution of essential scarce products and services to address the shortages of those products because of the rapid exponential growth of demand. And again, we all saw that. We all saw that happening, and this was the framework put in place to try to respond to that. And the same day, under that framework, there was the comfort letter to Medicines for Europe, the group formerly known as the European Generic Medicines Association. And that comfort letter was to allow those companies to cooperate in order to model demand for the medicines which were facing increased demand, to identify production capacity in existing stocks, and then to adapt or reallocate based on actual or projected demand those production stocks. So what this was about was allowing the generic companies to say, we recognize there's great demand for all of these products, rather than us all rushing to try to fix demand for one product and leaving another one unfulfilled. We can collaborate, we can talk to model what the demand will be, and then to allocate who is going to meet that demand. The kind of thing that would normally be a big competition. No, but in this case, it was understood that it needed to happen. We couldn't sit and wait for the market to work that out, and for the generics to go, oh dear, we're all doing the same thing, right, let's start up the new processes, because that's going to take weeks, months, or longer. And then the answer being in the comfort letter, and in the exceptional circumstances, that kind of cooperation doesn't raise concerns under Article 101. But it was also quick to point out that price discussion wasn't allowed. So the generic companies could discuss who was going to produce, but they couldn't discuss prices. And also, again, a concern about price rises. There was a requirement put on the participating undertakings that they wouldn't unduly increase prices beyond what is justified by possible increase in costs. So it's kind of by the back door of saying, we need this cooperation, you normally wouldn't be allowed to do it. Since we're letting you do it, you mustn't increase prices. They're not directly linked, but it was a way, an avenue for the authorities to put some kind of control over price rises, which they might otherwise struggle to do, and we'll see that theme continues. We have UK exclusion orders, the Competition Act 1998, Coronavirus Public Policy Exclusion Orders. Fascinating. I'm sure you've all read all of these already. Perhaps the most interesting one for present purposes would be the Health Services for Patients in England, which allows NHS bodies to cooperate, but also suppliers to the NHS to cooperate. So it allows that kind of level of cooperation. And that came in already on the 27th of March, so very early on, before we had the comfort letter from the Commission. It's been followed up in Wales just shy of a month later. I was doing some digging with contacts at Burness Paul today. As far as I understand it, there isn't a similar exclusion for Scotland or for Northern Ireland yet. We also have the groceries and dairy produce. Unsurprising that those were seen as priorities. Slightly surprised me more that the Solent maritime crossings was seen as such a priority that is one of the 5 exclusion orders, and that's the ferries to the Isle of Wight. We may come back to it, I guess, with some of the data privacy points later on that. So that's competition law. What about free movement law? And free movement law, it was immediately coming under challenge from a quite different way, in that every country was worried about shortages. And if you're worried about a shortage, the natural thing to do, say most countries, is stop people exporting, try to encourage production, but stop stuff getting out of the country and try to get it in as much as possible. Again, very early we saw reaction to that. On the 13th of March, we had the Commission saying that unilateral national restrictions to the free movement of essential supplies create significant barriers and affect dramatically member states' capacity to manage COVID-19. So the concern there is, we've got a single or internal market. If you start allowing member states to stop movement within that, then it doesn't operate well as an internal market. So one country helps itself to the detriment of other countries. So the Commission really pushed back on trying to stop that happening. Again, there's a worry about price rises, and in that context, the Commission says what you might be thinking about countries is price regulating in this environment to avoid prices being pushed up. So we don't like you putting export restrictions in place between the member states, but you might want to put price regulation in. The next day, perhaps in reaction and related to that, there was a regulation introduced by the Commission to require export authorizations for anything going outside the EEA. So the big worry was on restrictions within the European Economic Area, but then a separate regulation was saying, you know, that worry we have of things not being transferred within the common market, that doesn't apply to third countries. So third countries, that we will actually introduce a system saying export should only be allowed if we authorize it. That lasted for 2 months, so there's a lot of talk about how will things end. Well, this is one that has ended now. And what's particularly interesting, so I think you lost me just so I moved on to this slide. The UK had its own approach to what should be happening. And despite the very clear message from the Commission, there shouldn't be restrictions within the EEA, the UK has taken the approach to add restrictions on drugs being exported, not only on exports outside the EEA, but exports within the European Economic Area. It started quietly. We had 3 medicines added on the 25th of February to the list of don't export, and some of those will be familiar to those who've been following the drugs being used. Equally, on the 13th of March, we had 1 more. Then once the Commission said don't do it, things went bananas, and we had 82 medicines added to that list on the 20th of March and a further 33 on the 23rd of April. So the UK, in the face of those suggestions, there should not be restrictions on medicines, has said there are going to be restrictions on medicines. You're not allowed to export any of these medicines. And that's one of the questions that's been raised of what is the impact of Brexit on all of this, and what will the UK think of European rules? Well, we've seen, at least on free movement, what the UK's perception of European rules is on movement, at least of medicines. The final big topic then is state aid law and what happens with state aid law. This, for most of us, is absolutely a backwater of practice. It is not what we look at day to day. I had a quick look at again to see the kind of statistics. In the 3 months, March to May last year, there were only 64 decisions on state aid. 3 months this year, there have been 240. How has the European Commission expanded capacity to be able to make that many more decisions? Well, the main way it's done it is by introducing a temporary framework for state aid. And that says, it's a bit like the old block exemptions for competition law. If your state aid falls within these grounds, then it's likely to be okay, and we can analyze it quickly. The most interesting for an IP lawyer, I think, is the amendment on the 3rd of April, which was introduced to allow state aid which facilitated research and development on COVID-19 related issues. And that's quite extensive and has been used extensively by a lot of member states. And perhaps the most interesting piece then of that is that there is a restriction put on that state aid, that the aid beneficiary commits to granting non-exclusive licenses under non-discriminatory market conditions to third parties in the EEA. So this isn't a FRAND obligation. What one might describe it as a NEND obligation, non-exclusive, non-discriminatory licenses, conditions to be for access to the output from that state aid funded. That's interesting, and we really don't know how that is going to play out. We've seen Veale for years in the US, which has some degree of similarity where there's US government funded research and step-in rights, but not a lot of use of that. It will be interesting to see how that actually plays out in practice. But again, a bit like the rider put into the competition framework, where the generics were allowed to cooperate, but you better not increase prices. We've said state aid can be provided to allow this research and development, but you must grant these NEND licenses as a condition. And finally, come to the question of overpricing by exploiters and what the answer might be. And I've tried to pick this up as we go through. Competition law, we get these helpful statements which aren't suggesting there may be a great solution. Existing rules allow manufacturers to set maximum price for the products, and with the generics, it's subject to the not unduly increasing prices. The CMA perhaps came out a bit more clearly, the Competition and Markets Authority in the UK, in saying there is a problem with competition law in trying to deal with this. And we had the FT report on the 17th of May saying they were lobbying the government for emergency powers to crack down on companies profiteering from the pandemic after finding itself hamstrung by existing laws. And that's perhaps not surprising, given the limitations of law and that the CMA has been engaging for a number of years now in the pharmaceutical sector in looking at price rises and how price rises can be dealt with. So it was a known existing problem, but it's really been exacerbated at present, and the CMA has been lobbying heavily on that. Equally, under free movement law, we have these helpful hints that price regulations may be helpful to avoid soaring and abusive prices. So we've got the, within the context of trying to stop restrictions in free movement within the European Economic Area, the suggestion coming from the authorities that the way to deal with some of these problems will be to price regulate. Not something the UK government seems particularly keen on, and certainly not this UK government. So just for a change of territory rather than concentrating the EU, I was looking at the US cases dealing with this overpricing issue, and particularly the 3M and Performance Supply case, which I think is quite interesting. There the defendant had offered 7 million N95 respirators to the New York authorities, and they put up the price by 500%. 3M didn't like this. They said that is damaging to our brand because you are selling our product at increased rate, and there is that's going to have a reputation damage on us. They filed in the Southern District of New York on the 10th of April. Within 2 weeks, they had a temporary restraining order, and a couple of weeks later, they had their preliminary injunction. So trademarks have been used there as a way of dealing with that exploitative pricing rather than competition law or otherwise. So to sort of wrap that together, with competition law, cooperation, well, we might let you cooperate, but then you're going to be subject to price control. You can't increase your prices. Free movement law, it's hard to limit within a trade area, free movement, unless you're exiting that trade area, in which case you may give a very traditional British salute to those rules. State aid law, like competition law, a price will be required, and the price of aid may be named licensing, whatever that might mean. Overpricing by exploiters, we don't seem to have a great answer in Europe, but the US is showing the way that maybe trademarks will be the answer to that. And on that, I'll wrap up my presentation and pass back to Daniel.
Thank you very much, Chris. That was a formidable tour of 3 rather complex areas. Can I then turn to some questions and try and ask a composite question of the first 2 panelists, which have been raised by a number of people. First of all, in relation to the open source universe, how do you envisage authors and indeed publishers and universities and so forth actually getting paid for the creative work that they do, which is then being used? That's a first set of questions. And the second set of questions is, bearing in mind we're working in an international framework, how do you see the fact that, for example, teaching is taking place remotely and to other countries, meshing with the fact that copyrights are territorial and exceptions are territorial, and one needs to regulate the issue of what people can and can't do in a way that pays attention to the international nature of the activities? So 2 questions for you, first of all, and anyone else on the panel should feel that they can step in if they've got interesting contributions on that as well.
Okay, this is Paul. I can try and answer the first question about publishing and royalties and payment. In an open access world, you ask the question of your authors, why are you producing the material in the first place? And many authors who are embracing open access as the brave new world actually don't want royalties for their work. What they want is visibility for their outputs. And so for them, as in the example that I gave in my presentation about the textbook of burns and plastic surgery, Deepak could have published that with any commercial publisher and got substantial royalties if he'd wanted them. He said he didn't want them. What he wanted to do was make a difference, to add value to the clinical experience, not to make money out of it. So in an open access world, how do you get rewarded for being an open access author? You do it in different ways. You change your appointments and promotion schema to recognize engagement with open access, to make it possible for you to be promoted, for you to be appointed in the first place based on your engagement with open science, open scholarship. And in UCL, we have changed our academic promotions framework to make open access, engagement with open access and open science obligatory. It's a core requirement for your activity within the university. That's what I mean. That's what I meant when I talked about a change in academic culture that was required in order to deliver open access solutions. So we've changed the promotions criteria. People can use the new criteria which acknowledge openness to apply for promotion, to get pay rises, to be promoted through the grades. So yes, you can get paid, but it's a different way of doing it.
Thank you very much. Emily, any thinking on that?
Yes. So I think part of the answer to your question is we've been paid because we're doing our jobs. We've been paid through student fees. We've been paid through various research grants and so forth that are publicly funded. So as someone who draws, who sucks on the public teat, I think my work has already been paid for and needs to be disseminated freely to the public. Now, in terms of the economics of that, one thing to bear in mind too, so the universities have already paid for the stuff to be written because it's part of your contract of employment. Then there's a question about, well, what about the cost in then running the publishing house? I would suspect, Paul, it's probably better to comment on this, that when you start doing the sums on how much money you spend on monographs and subscription databases and so forth, and paying for open access with journals which offer open access but only on terms that you've paid for it, I suspect the economics might start to stack up that if you just instead put that money towards your own in-house publishing and your own in-house open access publishing, the sums may quickly mean that you're spending no more and potentially even less in that environment. So I think at least for universities, that would to me be the answer. Obviously for other authors in an open access world, there might not be exactly the same parameters and backdrop, but I'd say that for universities. The other thing too, which it can help deal with, to return to that question of territoriality, is that you can then release material on terms that in actual fact, whether you use Creative Commons or some other license, that in actual fact, all manner of forms of reuse are permitted. I mean, that's a whole sort of philosophy behind open access. So you're less concerned about, well, will the exception in this particular country apply? So the issue with territoriality is, as content is distributed around the world, if there's infringing acts by somebody in, say, Australia, we have to look at what Australian law says in relation to that infringing act and what do Australian exceptions say. Now, there's a degree of overlap between various exceptions, so I wouldn't want to overstate the risks of relying on exceptions even in an international context, but an open licensing approach and an open access approach may just make that give that greater degree of certainty.
Thank you very much. Michael and Chris, it would be useful to have your perspectives on, particularly on the territorial aspect.
I was thinking, so you know, I'm no expert on open access. In IT law, we publish a lot on open access, which is really nice. It's an area set up for that. But one thing I wanted to reflect on is that in areas like internet law, it's incredibly fast moving. And I think a lot of it's traditionally in internet law, people have always been willing to give their teaching materials away. People have been very generous and aware that there's a huge labor of changing it every single year. And of course, IP law has some of that as well. But I think taking the whole of the internet, it's very difficult. And it makes me think about other models for textbooks, kind of wiki-based models, or things that you can do with open access, which you can't really do with the slowness of traditional publishing. Such as expanding new chapters very quickly, such as updating, having large authorship lists, having a new case comes out, it's very easy to quickly add a paragraph and just add an author and so on, and to really collaborate and seeing that as a collective way of producing that material and giving more time for face-to-face with students and giving more time for other meaningful connections that go beyond what you can even do in a textbook at all. I think these kind of things are really exciting opportunities, as particularly the fast-moving fields, where we always struggle with setting texts that are too old, and people are just too exhausted to produce new editions which have substantively different content every couple of years.
Thanks. Chris, do you have any thoughts on the territorial aspect?
Well, on the territorial aspect, I think it's interesting because we've already seen, particularly that textbooks have led to territorial changes. I'm thinking particularly the Kirtzang judgment in the US, which moved the first sale doctrine from a national one to an international one, and that was driven by some of the pricing issues and the differential pricing that was textbooks being imported into the US from overseas. But I think the question of how academics are remunerated, I think we have to look also at the tech transfer piece of that as well as copyright, because I think it's one thing to say that academics shouldn't receive royalties and should accept that open access is part and parcel of the academic package. I think if you try and translate that to the tech transfer sphere, where academics are creating other IP patents, and often that is part and parcel of the job is they are given the opportunity to do that and profit by it themselves. Their pay is in large part driven by that piece of it. You can change that bargain, but you will very much change the people you get being academics in those fields. And I think that may be stronger in the fields where that is part of the remuneration package than where copyright IP is part of the remuneration package. And that can then lead to distortions within the academic market further.
Could I then come to a question which was asked, I won't say who it was, about the general issue of rights being diminished or suspended in times of crisis. Who and how should it be decided, when and whether they are restored, and if so, in what form? Perhaps I can go backwards in the panel. Chris, starting with you. You talked a lot about suspension of competition law. When do we get back to the normal?
Yes, well, with those, in some ways, that's an easier question because a lot of those regulations have provisions that provide when they will terminate. And the termination is generally when the pandemic is over, and they can be terminated with some degree of lead time, so 28 days once notice is given on them. So I think with a lot of those are very much driven by, they are specific exceptional circumstances. They've been set up with an end in sight. And obviously we saw on the export authorizations that end has actually happened. They haven't become the new normal. They were there for a period of time when there was a particular concern about PPE, and they led to an end. I think the harder question, and I'm probably more for the copyright lawyers in the panel, is how that's going to work, where there isn't a full return to where we were before, and the emergency doesn't stop because of the change dynamics. And I think so. I'd like to hear the others on it.
Michael, what are your thoughts on that?
Thanks. It's a really tricky question. So thinking of it from this software and new digital tracking infrastructures becomes very difficult. What we see with this is as the technology is embedded inside an operating system, we're not sure when it turns off. These are, on the plus side, the system that was put into an operating system is a privacy preserving system. It doesn't create a central database. It's not used as a data grab and can't be by Apple and Google. On the other hand, if somewhere in the world still has an outbreak, there will be an impetus to keep this system going, and it will, I think, become part of the infrastructures of life. One thing that's challenging is that many countries have suggested that alongside apps, they introduce primary legislation, and these create safeguards beyond privacy. So we've got quite strong privacy law in the UK. We could have a bit of a stronger regulator, I think, but we have quite strong privacy law. But the problems go beyond this. Think about, can someone demand to see that you have an app installed before they let you enter a pub or a place of work? Does the state have the power to mandate that such app is installed? These are not privacy issues, these are issues of coercion. And in Australia, which is admittedly not wholly known for leading the world on civil liberties, they put inside it actually a really nice primary set of safeguards. Sorry, Emily. Put inside actually quite a nice piece of primary legislation that has those safeguards in Switzerland as well, in Austria, and in Italy, lots of other countries have too. The UK robustly state they will not put legislative safeguards around this app, despite the fact that there's not overlapping provisions. These are wholly necessary provisions, I think, to ensure that people trust these systems. So, and those then relate to, I think, installing sunset clauses and thinking about what the actual tangible conditions are about that. But one last point to reflect upon is, definitionally, when does a crisis end? You know, is it when coronavirus is not in the UK? How do you put this into statute? Is it when the minister says so? Is it when no country in the world has it? Is it when no country that has frequent travel has it? It's not clear, and I don't think this will be an easy process to unpick some of the infrastructures that we lay, which is why we tried to lay infrastructures that at least do no harm, even if they go wrong, because we expect them to be around. Passports stuck around after World War I because of the Spanish flu, and anything we build now we have to expect may stay around similarly.
Emily, do you want to defend your country?
Not really. I think that was an accurate appraisal. But I can say something and answer this question, unless you want to Paul first. Okay, I think I'm going to avoid the question. I'm going to avoid it by saying, in actual fact, I think for copyright, what we are seeing is that the academic publishing system is not fit for purpose. So it's not a matter of the pandemic coming to an end and we can all just like go back to normal. I think there's a critique of whether normal was actually the best way to go. And as we argue in the piece, it may be that the pandemic is a time when actually universities see particularly strongly the repercussions of this system, which we've been participating in for years, where we undertake research and teaching, and we write outputs, monographs, textbooks, etc., and then somebody else then gets commercialized and to control them. And I think, I mean, sometimes one of the ironies I think about COVID is, and I've seen this in a number of different media reports, is that many people who, for reasons, for instance, of disability, can't go to the library or can't access collections, they're saying, welcome to my world. This is what's been already going on for me. And whether or not this provides an impetus for institutions to say, well, actually, this just gives us yet another reason why we need to take a different approach. Now, in the Q&A stream, there was a question from Chris Morrison in relation to how do we persuade academic authors to engage with open textbooks. This seems to be a low priority, and I think there's probably something fair in relation to that. I've seen movement, particularly in intellectual property, from US colleagues who there are a lot of casebooks being made now that are available in open access terms. But I wonder whether part of it is just an incentive structure that I think many of us deep down would like to do more in open access, but we're concerned about promotions and appointments, all the stuff that Paul was talking about in his presentation. Perhaps too, we need to get over ourselves a bit with the ego in terms of I published with the top journal and there's the top publisher, and we need to try and move beyond that as well and think about the degree to which we get some ego boost from certain things. But as I think, to me, in actual fact, we need to say that the changes we're making are not just for the pandemic. They are actually changes which respond to much more fundamental problems with academic publishing.
Thank you very much. Before I turn to Paul, if he wants to comment on that, there was a question that's just come in about whether there should be a multilateral government agreement to govern IP royalties relating to a COVID vaccine. And that links more with what we were thinking about last week. But it also is relevant here as to what legislative level some of these issues should be addressed at. one of the things that we have been seeing is that national governments have taken quite a national response to this crisis, rejecting EU regulation and so forth. What would you say is required in terms of international or regional regulation in the various areas that you have been focusing on? Why don't I start with Paul and then go back round? And perhaps we'll treat this as the wrap up because we're already nearly at 7:30.
Okay, thanks. I'll do my best to answer the question. I'm really going to pick up some of the generic points that Emily made that I've been trying to make throughout the presentation. Crisis is one of the greatest threats to global systems, the Spanish flu epidemic of the early 20th century. And what we need to do as we're dealing with this crisis, trying to emerge from it, is to treat it not simply as a threat, but a series of opportunities. And that's really the message behind my approach to open access and licensing. Let's not worry about the difficulties. Let's look at the opportunities for absolutely changing the system. So let's apply that principle to licensing of a COVID-19 vaccine. I'm not a lawyer, but it seems perfectly clear to me that if a vaccine is produced, it should be freely available, openly available to everybody, anywhere in the world. It can't be tied up behind licenses. It can't be tied up behind cost structures. We have to fundamentally rethink what the world is that we're working in and how we want to operate in it to make sure that we can tackle and this crisis and turn threats into opportunities. So I'd say no licensing, which is going to be restrictive, no prices, which are going to be restrictive. Like open access, it should be freely available and available for everybody. And that's a condition that we all need to accept in order to take this change in culture forward.
Thank you. Emily, a few brief concluding remarks?
Do you know what? I think I don't have any more remarks.
Good. I'll move on to Michael.
I have one quick remark, which has been fascinating. When we published the code for this app and protocol, we, as I said, we did it openly and with a weak copyleft license. And other countries, either that developed our code, or they have to, but even if they develop their own code, have also been doing this. They've been, even you can see they've actually copied the way we've done it, in the way they've released it and the way they phrase it. And this is government apps in countries around the world, even countries which don't have great human rights records, being published openly, open code for scrutiny. And that's a great sign. So we can have some norms that change from this too, I think. And I hope that in some countries which have never published open public sector software before, that this helps spark the fact that this can be a great thing going forwards. So there's some silver linings we can read in other sectors too.
Thank you very much. Chris, a few thoughts?
Well, yeah, I guess I'd like to wrap up by disagreeing quite fundamentally with Paul on the IP side. I think it's pretty clear that the challenges when we have a vaccine or other treatments is going to be getting them in a large enough volume, produced and distributed as fairly as possible around the world as quickly as possible. There is just a capacity problem. It's not an IP problem. It's a capacity problem. And I think that there are long-standing debates about access to medicines and IP and the issues in that. And what I'm seeing is a lot of the usual arguments being put forward in that being wrapped up into the coronavirus debate. And I think it's quite a different debate, because I think we are focusing on not IP issues so much as on how do we deal with just the volume that you need to respond. And that presents a different range of challenges. That presents challenges of perhaps people in richer countries saying, I know I would like to have the vaccination so I can get back to work, but it is more important that healthcare staff in other countries get it before me. And I think there's a lot of personal issues that become quite difficult issues there. I don't think they're anything to do with IP. I worry that, I mean, I think I'm quite excited about all the collaboration, all the development, all the new IP that's going to be coming out, which won't all be COVID related, but may have other uses. But if we start slamming the IP system now for a reason that isn't necessary, we really risk undermining all of that coming through and all those developments coming through. So I think I do quite strongly disagree on the idea that we need to get rid of all IP in order to make sure this vaccine gets out. I don't think that's the problem.
Well, that's an absolutely fabulous note on which to end, namely divergence of view from different academic perspectives on the utility of IP. I have to say that rather does confirm what was said right at the outset, that this is a perennial debate, and the issues are in some respects no different, but illuminated by recent events. So thank you all very much, Paul, Emily, Michael, Chris, for excellent presentations, to UCL, Lisa and Lynn for all of the administrative support, and to Robin for putting everything together as he always does. And thank you to all of you for coming, and to so many of you for staying even until 7:30. It is just sad that I can't at this moment say, now of course we're going for our usual drinks in UCL. You're going to have to open your own bottles or whatever it is now and drink to them. Thank you very much indeed for attending.